Imagine being approved for your green card after years of waiting, and then being told you need to hand over $100,000 in cash before you're allowed to actually come to the United States. That's not a hypothetical, it's a real proposal currently being evaluated by the State Department. Welcome back to US Visa News Hub. I'm Mr. Burhan, and if you're not subscribed yet, this is exactly the kind of update you don't want to miss. This video is for informational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your situation. Let's start with what we actually know, because this story broke through Wall Street Journal reporting on July 15, 2026, and it's important to be precise about where things stand. The Trump administration, through the State Department, is considering requiring certain immigrant visa applicants, people applying for green cards through U.S. consulates abroad, to post a refundable bond of up to $100,000 before they're permitted to immigrate. State Department spokesperson Tommy Pigott confirmed the administration is evaluating this, framing it as another way for applicants to demonstrate financial self-sufficiency. But here's the key thing to understand right now. As of today, this is a proposal under review. It has not been finalized, it has not been published as a formal rule in the Federal Register, and nobody is being asked to pay this bond at this moment. If you have a pending immigrant visa case, nothing about your current process has changed because of this news. This video is for informational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your case. So, where does this idea actually come from? And does the government even have legal authority to do this? On the legal authority question, the State Department has pointed specifically to INA Section 221G, which allows a consular officer to invite a visa applicant to post what's called a public charge bond, when that applicant would otherwise be considered inadmissible under the public charge provisions of immigration law. That's real, existing legal authority. This isn't something being invented from nothing. That said, immigration officials themselves have reportedly expressed some uncertainty about whether this existing authority actually stretches far enough to support a bond at this scale, applied this broadly, which is part of why this remains a proposal rather than a finalized policy. As for where this idea comes from practically, it didn't appear out of nowhere. It's modeled directly on a pilot program the State Department has been running since August 2025. Under that program, certain B1 and B2 visitor visa applicants from Malawi and Zambia were required to post refundable bonds of up to $15,000, which would be forfeited if the traveler overstayed their visa or tried to change their immigration status after arriving. That program has since expanded to roughly 50 countries, mostly in Africa, and officials have cited a compliance rate around 97% as evidence the approach works. It's worth knowing the other side of that data too. Critics point out that visa approvals from those same affected countries dropped significantly, by some reports as much as 83% once the financial barrier went up, suggesting the bond may be discouraging legitimate applicants just as much as it's preventing overstays. In fact, that visitor visa bond program is separately becoming permanent as of August 3, 2026, with a maximum bond amount rising to $20,000 for B1/B2 applicants from those 50 designated countries. So this isn't an isolated one-time idea. It's part of a broader pattern of the administration expanding bond-based screening across different visa categories. Now, here's an important distinction that immigration attorneys have specifically flagged, because it explains why this proposal might be more legally durable than a similar effort that already failed. Earlier this year, the administration attempted to impose a $100,000 fee on certain H-1B petitions. A federal judge struck that fee down in June 2026, ruling it functioned as an unauthorized tax that exceeded executive authority, since only Congress has the power to impose a tax like that. The green card bond proposal is being deliberately framed differently, not as a fee, which is non-refundable government revenue, but as a refundable bond, which is a financial guarantee rather than a tax. That distinction doesn't put this proposal beyond legal challenge entirely, but it does close off the most obvious legal argument that succeeded against the H-1B fee, which is part of why immigration attorneys are taking this proposal seriously rather than assuming it will simply be struck down the same way. Let's talk about what refundable actually means here, because the details matter a lot. According to reporting, applicants would only get their bond money back after becoming a naturalized US citizen, a process that typically takes at least 5 years after receiving a green card, sometimes longer. During that entire multi-year window, the government would be holding that $100,000 without paying any interest on it. And if a green card holder later relies on certain forms of public assistance or fails to meet other program conditions, reports indicate the government could keep the money entirely rather than returning it. This would also come on top of costs that already exist. Applicants currently pay a $325 DS-260 visa application fee, followed by a separate $235 USCIS immigrant fee once their visa is approved. The proposed bond wouldn't replace those costs, it would sit on top of them. It's also worth connecting this to another policy shift we've covered before on this channel. Back on May 21, 2026, USCIS issued a memo emphasizing that adjustment of status inside the United States is a discretionary benefit, not an automatic right, and that consular processing abroad should generally be treated as the default path rather than the exception. This bond proposal fits into that same broader pattern. It specifically targets people applying for green cards through consulates abroad, which is exactly the population that memo is already steering more applicants toward. So even before this bond proposal is finalized, we're seeing a consistent direction from this administration toward tighter financial and discretionary scrutiny, specifically for consular-processed green card cases. So given all of this, what should you actually do if you have a pending or planned immigrant visa case abroad? First, and most importantly, don't panic and don't pay anyone who claims you need to post a bond right now. As of today, this is not a real requirement, and no legitimate part of the current consular process asks for anything like this. If anyone contacts you claiming otherwise and asks for payment related to this proposal, that is very likely a scam, and you should not send any money or personal financial information. Second, if you have a green card application currently moving through consular processing, continue following the normal process as it exists today. This proposal, if it moves forward, would need to go through a formal rulemaking process, which typically includes a public comment period, before it could actually take effect. Third, given how quickly immigration policy has been shifting in 2026, it's genuinely worth staying closely connected with a qualified immigration attorney who can flag the moment this moves from proposal to actual policy, rather than finding out after the fact. We are going to keep a close eye on this story, because if this bond requirement is formally proposed and finalized, it would represent one of the largest financial barriers ever placed on legal immigration to the United States, and it would directly affect family-sponsored and other consular-processed green card applicants around the world. If this was helpful, share it with anyone you know who's currently navigating a consular green card case, and subscribe to US Visa News Hub so you're among the first to know if this moves from proposal to reality. Thank you for watching. This video is for informational and educational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your situation.